When parents disagree about custody across borders, it depends upon how their disagreement originates. If one party just runs off with the other child, well, all of a sudden they've thrown it into a battle, right? And a battle provokes a battle, and battles provoke wars. If parents disagree about custody when they aren't yet entrenched in their position, they have a much better chance of working out a solution that they can live with. They have a much better chance even of getting a ruling from a court that they can live with because they haven't engaged in self-help, which is kind of like being a vigilante. So the best thing to do would be to consult with an attorney about what you would like, hear what your options are, and then make the best strategy that's going to accomplish your objective, right? So if that is taking off, then that's taking off. But if that is going ahead and entrenching where you are and fighting that battle where you are, that may well be the answer. I'm thinking of several cases where people got mired in litigation on different continents, and it made the press, and it was very interesting to read, but it was very destructive to the parties, and it wound up, and this is a sad part about it, it wound up with a resolution that you could have identified from the very beginning, saving literally hundreds of thousands of dollars. So I would encourage people not to make that needless mistake. Courts determine jurisdiction in custody cases and international custody cases depending upon which court is asking the question. If it is a Hague Convention case, then the court is asking the question based upon habitual residence more than anything else. There's also a standing issue that has to do with whether or not they're custodial rights, but really habitual residence, which is where is the child resided, and that ends the analysis for that part of the question. If the court is trying to determine that question from a custodial question, and let me put that a bit more in context, like a divorce has been filed, right? And the court that is looking at that question is a court of that capacity, one that's going to issue the divorce. Then they're going to ask custodial questions or jurisdictional questions based upon their statute. In the United States, for example, it would be done under the UCCJEA, Uniform Child Custody Jurisdiction and Enforcement Act, which is true in 49 of the 50 states. Massachusetts has a slightly different variation on it, but it works well within the UCCJEA. And so it is the same statute in every state, right? So you can track it. In New Jersey, it reads exactly the same way as it reads in North Carolina, as it reads in Georgia, as it reads in Florida. You get the idea. And that has to do with, if this is the first time this question has been asked of a court, it's an original custody proceeding, and the simple question is, where's the child resided for the last 6 months? You can get into some nuances, like what happens if you have a child that's 5 months old? And there are courts that have resolved that question. But by and large, it's where has the child resided for the last 6 months? So if you're asking the same question out of England, England's going to follow its statute on jurisdiction. Same for every other country. They'll have a statute, they'll have a standard on how to resolve jurisdiction. The role of mediation and negotiation in Hague cases is largely pro forma. In Hague cases, the parents have really squared off. My child, not yours, is probably the best way to put that posture. It is hard to negotiate through that. It is hard to mediate through that. Now, judges love mediation because it makes it less likely that they have to try the case. So they will order mediation almost every single time. But the success in a divorce case in mediation is high, better than 80%. The success in a Hague case through mediation is low, better than 5%. So you may have to have mediation just because it's going to be court-ordered in a Hague case, but don't expect much from it because, again, the parties are entrenched. They're not disposed to come to an agreement with each other regardless of the terms. Parents can protect their rights when moving abroad by having clear rules and clear understanding. If we're talking about a situation where parents are about to move abroad together, right, as an intact family, what a brilliant time to pause, go see an international custody lawyer, and say, this is what our understanding is. An example that I often give is in England, they have a habitual residence test that when a child touches down on the tarmac, the child becomes a habitual resident of Great Britain, of England. That is true because they believe that the parties have agreed to that. So how do you defeat that? You come to a written agreement that says, no, that's not what we intend. In much of U.S. law, what it talks about is the party's intention, the party's conduct that helps the court understand their intention. And without any written expressed intention, the example that's often given is an exec gets transferred to a foreign location. And the company says, congratulations, Mary, you're going to this foreign location to start up this new branch, and you will be there for 11 months, 12 months, and then you're coming home. And there are clear terms, because corporations work through fairly clear terms. There are clear terms of engagement. Here's when you start, here's where you come home. Then the court will say habitual residence did not transfer because there was no settled intent to remain. Change up the facts for a minute. Congratulations, Mary, you're going to go over to this new location abroad and start a new branch of our company, and you'll be there until, right? And the posting is intentionally without an end. Then the courts, by and large, will say there was an intent to settle there, right? Because there was no clear time to come home. So rather than leaving it up to the expressed statement from an HR department, it is far better for the parties to sit down, sort of like a prenup, except we'd call it a variation on a postnuptial agreement. Sit down and work through, what do you mean by this? Congratulations, you're going off to Paris. But what does that mean? What does that mean for your children? What does that mean for how you're going to raise them, where you're going to raise them, what you intend for them long term? You can work all this out now, particularly before you come to a disagreement about whether or not Paris is wonderful and you want to live there the rest of your life, or it was interesting eating baguettes for a year, but it's time to come home. If you find yourself in the middle of an international custody dispute, either after something's already happened and you got to resolve it, or before something's happened and you've got the wisdom to try to resolve it in advance, give us a call. We're here to help.